May I ask those who are standing to please find a seat. We usually give about 5 or 10 minutes at the beginning of our Braintrust leeway time, but I'm going to not do that today because we have a very, very packed schedule and people who have very tight schedules to operate on. And I know that we want to maximize our time here, and sometimes they come at the end of our Braintrust and put us out of the room too, so we can't go over at 5 o'clock. I'm Congressman Mel White. I represent the 12th Congressional District of North Carolina, and it is my pleasure to have hosted a discussion on voting rights, some years pleasure, some years displeasure, for the last 21 years that I have been here at this conference. It started out as an issues forum, and it didn't take long for us to convert it to what we call a brain trust. And most of you won't understand the distinction, but issues forums deal with issues that kind of come and are there for a short period of time and then they go. And brain trust deal with things that are continuing, ongoing issues that seem never to go away. For example, the Congressional Black Caucus Foundation and the CBC have a brain trust on health. That's an issue that we work on. We have a brain trust on education. We have a brain trust on crime. And in 1992, 1993, when I was first elected, we had a rash of redistricting based on the 1990 census, and we increased the African American representation in Congress to a level that was unprecedented, and we were naive enough to think that maybe this would be a transitional issue, it would go away. Then the lawsuits started to be filed, and during the first 10 years that I was in Congress, I represented at least 3 different district configurations and a total of 5 or 6 congressional districts were actually drawn for me. In some cases, they drew congressional districts and they were thrown out before the next election, so I never got a chance to run in them. And it became obvious that this was not going to be a subject that would be the subject of an issues forum, so we converted it to a brain trust. As part of that process, of trying to save the congressional districts that had been drawn based on the 1990 census, there was substantial litigation, as many of you know. And one of the persons who took up leadership in the cause to save the districts that had been drawn and to protect the Voting Rights Act was former Judge A. Leon Higginbotham. He marshaled forces, much as they had leading to the Brown versus Board of Education decision. He marshaled political scientists and researchers and lawyers and put them together to try to build the case for minority representation. And the Congressional Black Caucus filed an amicus brief in some of the litigation that was filed with Judge Higginbotham, or former Judge Higginbotham, leading the way in that endeavor. And then, this is a lot of history, but I'm concising it for you. At some point, A. Leon Higginbotham passed away. And at that point, we changed the name of the what was an issues forum and then became a Braintrust. We changed it to the A. Leon Higginbotham Memorial Braintrust. So there's history here, and part of that history is that we always take a moment at the beginning of the Braintrust to pay tribute to Judge A. Leon Higginbotham, who was so instrumental in trying to protect our congressional districts going all the way back into the 90s. And this year, I think we should add to that list of people that we pay tribute to Attorney Julius Chambers, who died recently. He was my senior law partner and the former director counsel of the NAACP Legal Defense Fund in New York. And so if you will just, we won't do the tributes this year because we've got a packed program, but I think we'd be remiss if we did not at least observe a moment of silence in memory of A. Leon Higginbotham and Julius Chambers for the roles that they played in this arena and in our lives in general. So please join me for a moment of silence. Thank you. Now, I don't think I've ever been as excited about the program that we have laid out for this Braintrust in any year as I am this year. I'm not excited about where we are in the voting rights arena. As you will see, there are substantial challenges, but as a result of those challenges, we have been even more deliberative in the way we have approached the organization of this discussion today. And we thought it was important to cover three distinct areas. And I want to give special thanks to Stephanie Moore, who always is at the center of sitting down with me and thinking through how we should organize this. At the time the A. Leon Higginbotham Memorial Braintrust was put on the schedule for this annual legislative conference, it was before the Supreme Court had decided the Shelby case, and we knew that there would be a decision, but we didn't, so we gave it an amorphous title. Don't be misled by the title to the Braintrust. We knew we were going to talk about voting rights. But after the decision came out, we spent some time thinking about how to organize this, and this is where we got to. I am so privileged, and I'm assured that he's on the way because he just left the Department of Justice. I got a note saying that. That the Attorney General Eric Holder is going to join us shortly, and he is going to be the first part of this presentation. And his primary focus will be to talk about what can government do, what can the legal structure within the government do in light of the fact that we have no pre-clearance requirement in the voting rights law anymore based on the Supreme Court's decision. They struck down 15,000, 20,000 pages of legislative history to conclude that the justices, 5 justices on the Supreme Court, knew more about what was needed in this area than 435 members of the House and 100 members of the Senate. So there is no Justice Department pre-clearance for voting rights decisions anymore. But there are still some things that the government and the Attorney General and the Justice Department can do, and we expect Attorney General Holder to have a robust discussion about that. I think he is going to have to leave right after he makes his presentation, so we may not get to have a dialogue with him, but we didn't want to miss that particular role. The second part of the program today is a rare opportunity because we have the opportunity to hear from my colleague from Virginia, beside whom I have sat on the Judiciary Committee for 21 years now. Most people can't tell us apart. When he goes to the floor and says something controversial, my phones light up. When I go to the floor and say something controversial, his phones light up. Bobby Scott and I are inseparable, and we happen to be best friends in Congress. So, and he's going to talk about an aspect of this in conjunction with my good friend, Congressman Jim Sensenbrenner from Wisconsin. Now, Jim's a little bit different here because he is both a Republican and some people might not think he's got as much interest in this, but I want to tell you by way of introducing him, and I'm not going to come back and introduce him again when this is over. I'm actually doing all of this waiting on the Attorney General to arrive. He's here. He's back there. Okay, so but I'm going to finish this part of the introduction, and then I'll finish the layout of the program. Jim Sensenbrenner has been committed to a Voting Rights Act that protects the rights of African Americans and minorities in general to vote for years, going all the way back, not as far as John Conyers, who I saw in the back room, back of the room. Is John back there somewhere? Didn't I see John wander in here? John was here when we first passed the Voting Rights Act. And he was here for the first extension of it. And he was here for the second extension of it. And he was here for the most recent extension of it. You weren't here for all of those, were you? You weren't here for the original one. But Sensenbrenner has been, Jim Sensenbrenner has been with this cause throughout this process of renewing the Voting Rights Act and extending it and giving it life. And Jim Sensenbrenner and Bobby Scott are going to talk about, in light of what the Supreme Court has done, is there something that we can do legislatively to respond to how bad the Supreme Court has messed this up? Okay? That's the second part of this. And then the third part of it, I won't introduce them right now. I'll come back and introduce them later. We have the current Director Counsel of the NAACP Legal Defense Fund, Sherilyn Eiffel, and we have Anita Earls, who from the very beginning, going all the way back in 1990, was one of the lead counsel in the Shaw versus Reno case, which protected my existence here. So they're going to talk about some legal aspects related to this outside the government, and hopefully at the end of the day we can tie all of this together, government, legislative response, legal response, and have a discussion. And I hope we have a little bit of time at the end to get some feedback. So without further ado, let me introduce Attorney General Eric Holder, the 82nd Attorney General of the United States, and he became the first African American to hold the Attorney General's position in the United States in 2009. He was appointed to several government positions prior to becoming Attorney General by both Democratic and Republican presidents, including his appointment as Deputy Attorney General by President Clinton, and his nomination to become an Associate Judge of the Superior Court of the District of Columbia by President Ronald Reagan. Immediately prior to becoming Attorney General, he was a litigation partner at the law firm of Covington and Burling, so he has private sector experience. And some years ago, he clerked at the NAACP Legal Defense Fund, which I'm sure Sherilyn's going to brag about. After finishing law school, he came to D.C., joined the Department of Justice as part of the Attorney General's Honors Program. He's a native of New York, graduate of Columbia College and Columbia Law School, and it gives me a great deal of pleasure if we can roll the drums and we can get this door to open back here. We're going to get him to come in this way to introduce the Attorney General, my friend, Attorney General Eric Holder.
Peekaboo.
Well, I got to tell jokes. Hey, where's Stephanie? Stephanie, go find the Attorney General. Somebody issue a summons for him. Let's subpoena the Attorney General and get him in here. Sensenbrenner says we've tried that before on some other issues. Not on voting rights. He's here. Are you ready, Congressman? Yes, sir. I've introduced him. We had a drum roll. We had banners flying. Now, y'all don't tell the Attorney General anything bad I said about him in the introduction. He's my friend, and I'm going to call him right up here right now because you are on. See, I was stalling in your introduction until you got here, and then I went back there and you weren't there.
Oh, all right.
Welcome.
Good to see you, sir.
Thank you so much.
Well, good afternoon. It's great to be here. We've got three powerful members of Congress here. That's always good to have them here and engaged. I want to say this, really a pleasure for me to be here today, and a privilege as always to stand among so many distinguished public servants, some good friends, and passionate men and women like yourselves who have dedicated their lives to the fight for equal rights and equal justice, both in your own communities and here in our nation's capital. It's an honor for me to share the stage with this very distinguished panel, and I'd particularly like to thank the Congressional Black Caucus Foundation for organizing this event and for bringing us all together. Through scholarship as well as through advocacy, this organization has stood for decades at the forefront of critical dialogues about civil rights, about education, healthcare, economic development, racial disparities, and also about criminal justice. Over the years, you have repeatedly proven your commitment to constructive engagement and thoughtful discussion on subjects that are both difficult and sometimes divisive. But even more importantly, you regularly come together through forums like this were to translate ideas and shared values into principled and effective action. Now, in many ways, the CBC Foundation is leading national efforts to honor the achievements of our past and to extend the legacies of the civil rights milestones that millions have paused to observe this summer. From the integration of the University of Alabama by my late sister-in-law, Vivian Malone, and another student 50 years ago this past June, to the senseless murder of Medgar Evers that happened the very same night. From the March on Washington, half a century ago last month, to the bombing of the Birmingham 16th Street Baptist Church 50 years ago last Sunday. Alongside President Obama and our colleagues throughout the administration, you have joined in ceremonies to pay tribute to the pioneers who organized, who rallied, who sacrificed, and who often died to bring about the progress this nation has witnessed over the past 5 decades. You've also shown that you recognize, as I do, that we can best honor these brave men, these brave women, and innocent children, not merely by reflecting on our past and celebrating the achievements of the present, but also by continuing their work, which has now become our work, into the future. So this means standing up. It means standing up means speaking out for the civil rights to which everyone in this country is entitled. It means calling attention to persistent disparities and inequities, including those that plague America's criminal justice system, some of which I discussed at a conversation I had just yesterday in this same building. And it means working tirelessly to safeguard what's been called the most basic of American rights, the right to vote, and ensuring that despite recent setbacks, our time is defined by the continued expansion of the franchise. It was nearly half a century ago when President Lyndon Johnson signed the landmark Voting Rights Act of 1965 into law in order to preserve what he called, and I will quote, the dignity of man and the decency of democracy. Now, near the height of the civil rights era, he reaffirmed his commitment to President Kennedy's ambitious agenda by joining countless Americans, seemingly ordinary, but all really extraordinary, in rejecting the forces of bigotry and injustice. And he asked, how could a great nation whose strength is rooted in its ability, the ability of its citizens to choose their own leaders, could deny the right to vote to any citizen to cast a ballot? And when Congress finally took action to pass the Voting Rights Act, he signed this historic legislation in order to codify into law a truth that had been called self-evident, but left unrealized nearly 2 centuries before, that all men and all women are created equal. Now, the enactment of the Voting Rights Act was a vindication of untold millions who had taken to the streets of this city and others across the country, braving dogs and fire hoses, billy clubs, and baseball bats, bullets and bombs to secure these rights which were theirs as Americans. This law empowered the United States Department of Justice to fight unjust attempts to abridge voting rights and to restrict access to the franchise. And for nearly 5 decades, it proved to be a robust, enforceable safeguard that helped to protect the right of every American to cast a ballot, unencumbered by discriminatory rules, regulations, and procedures that intentionally or not discouraged and disenfranchised. And this is why members of Congress and presidents of both parties have consistently supported the Voting Rights Act, including its most recent reauthorization in 2006, which, thanks to the extraordinary efforts of a great congressman, Jim Sensenbrenner, who I think we should all be honored to have with us here today, received near unanimous support on Capitol Hill and was signed by President Bush. At the center of every version of this law was a requirement known as pre-clearance that put on hold any new voting changes that were adopted by covered jurisdictions until they had been subjected to a fair and a thorough review. Now, this process regularly resulted in approvals for impartial voting changes while also allowing the Justice Department to work with covered jurisdictions to address problems wherever they might occur. Now, unfortunately, in June, as you all know, a narrowly split and a deeply divided Supreme Court struck down the part of the Voting Rights Act that determined how this important requirement was applied. Now, let me be clear. From my perspective, this was a deeply flawed decision that effectively invalidated a cornerstone of America's civil rights law. And although it has had a significant impact on the Justice Department's enforcement abilities, as President Obama and I have said, and as my colleagues and I think are already proving, we will not allow the court's action to be interpreted as open season for states to pursue measures that suppress voting rights. This decision has not, and it will not, weaken our resolve to ensure that every American exercise his or her rights freely, fairly, and without intimidation or interference. Neither the President, nor I, nor the department that I am honored to lead will waver in our determination to stand vigilant against any changes that may hamper voting rights. We will not hesitate to take appropriately aggressive action against any jurisdiction that attempts to hinder access to the franchise. And we will continue to vigorously enforce federal voting laws that have not been affected by the Supreme Court's decision, including all remaining parts of the Voting Rights Act. Now, this constitutes, I feel, our obligation and also our solemn commitment, a commitment that we're backing up with action. Earlier this summer, I announced that the Justice Department has asked a federal court to submit the state of Texas to a pre-clearance regime that is very similar to the one required by Section 5 of the Voting Rights Act. Since then, the department has also challenged the state's restrictive new voter identification law. Thanks to the hard work of our Civil Rights Division, we are continuing to refine and to refocus current enforcement efforts across the country. And while the suit that we filed in Texas marked the first voting rights enforcement action since the Supreme Court ruling, this will not be our last. Of course, the responsibility to protect the rights of every American does not end with the Department of Justice. It has always been up to every citizen and every public servant to stand against discrimination wherever it is found. And this is an issue that transcends partisanship. It's about who we are and who we want to be as a nation. And it's clear that the Justice Department's ongoing work will never be a substitute for public engagement or for congressional action. And that's why I think that we must regard this recent setback not as a defeat for the cause of voting rights, but as an opportunity to ensure that modern protections are adequate to the challenges of the 21st century. I know that all of you, along with the President and the members of the House and Senate from across the political spectrum, share my commitment to this goal, and no one more so than Congressman Sensenbrenner. Now, he didn't hesitate to jump to action after the Supreme Court's decision, immediately acknowledging that the Voting Rights Act, and I'm quoting now, is one of the most important pieces of civil rights legislation ever passed, his words. And I wholeheartedly agree with his observation that the law is, and I again quote, vital to our commitment to never again permit racial prejudices in our electoral process. And it is my hope and expectation that together, we can find a responsible way to move forward, recognizing that the country we love is greater than the interests of any short-term goals. As concerned citizens, as passionate advocates, and also as public servants, everyone in this room has been charged with upholding the ideals that define this country. The stakes are simply too high, and the potential costs are too great to devote anything less than our best efforts to the protection of these rights. We know from our history and from the milestones that we have celebrated this year that advances in civil rights and voting rights have been hard-won, and they were not inevitable. And that's why we cannot, we must not, and we will not simply stand by as the voices of those disproportionately affected by some of the recent proposals that we have seen, the poor, the elderly, the infirm, the young, and people of color, are shut out of the process of self-determination. For more than 2 centuries, this nation has been built, and it continues to be improved both by and for the people, generation after generation. Our course has been set by patriotic Americans like all of you who come together to push this country forward based on common ideals and mutual understanding. Now, our progress has always been of our own making, and today this progress is entrusted to each of us, to each of you. It belongs to men and women of courage and principle who continue to call for and work towards a more just and a more equal America. It belongs to those who envision a future where our daughters are guaranteed the same rights and opportunities as our sons. It belongs to advocates who keep standing up for the principle that no one is too small to deserve equal treatment under the law, and no one is too big to escape it. And it belongs to the leaders in and far beyond this room who recognize that the free exercise of our fundamental rights must never be subject to politics or geography. On the contrary, they must always be the birthright and the solemn responsibility of every citizen. Now, our work is not yet finished. Significant challenges remain before us. But as I look over this crowd today, I cannot help but feel confident in where our collective efforts will lead us. I'm proud to count each one of you as a colleague and an essential partner in the work of building a more perfect union. And I look forward to all that we must and surely will achieve together in the months and years ahead. So thank you once again for your commitment to this work and for the dialogue that we're building here in Washington this week. I wish you all a most productive discussion, and I look forward to the work that we will do together to make this union of ours even more perfect. Thanks very much.
So I'm pleasantly surprised because I thought the Attorney General was going to have to leave, but he says he's going to stay for a little bit, but not for questions and responses at this point. So, but he's going to stay with us, and we got to keep moving on the program because for those of you who do not know. The House of Representatives has completed its work for the week. We knew that by the time we got to this Braintrust this afternoon, that would be the case. And when I approached Congressman Sensenbrenner, I knew that he would have other commitments and he would be trying to get out of town. But I also knew that if I leaned on him enough and prevailed on him, he would stay around long enough to make a presentation. And he does, in fact, have another commitment, so I want to rush to get to him, but I want to get to him this way. I was the chair of the Congressional Black Caucus when we set about trying to renew and extend the Voting Rights Act. And the Judiciary Committee has a history of of dealing with issues that can often send us off in different philosophical directions. And Jim Sensenbrenner and I had a long history of being off in different directions on a number of issues. And I will tell you that I gained a respect for this congressman that is unequal to many of the relationships I have with members of Congress, because I remember a meeting in his office where we sat down, and I, by that time, had understood his historical connection to the Voting Rights Act and his commitment to the Voting Rights Act. And I was seeking his ongoing commitment to extend the provisions of the Voting Rights Act, and he did not equivocate, he did not hesitate. And I remember sitting in his office and making a pledge with him that if he would fight off the people from the right who wanted to do away with the Voting Rights Act, I would stand back to back with him and try to hold at bay the people who wanted to put everything in the wash and include it in the renewal of the Voting Rights Act, whether it had anything to do with voting rights or not, so that we could get the Voting Rights Act extended and do it on a bipartisan basis. And Jim Sensenbrenner has never backed away from that pledge that he made to me on that occasion. We have stood back to back. We've become friends. We still disagree on a lot, don't get me wrong. But on this issue, he has been a real ally and friend, and I'm honored now to call up Representative Jim Sensenbrenner of Wisconsin to make a presentation. I know you're not accustomed to that.
Well, yes, I am. Talk about that. In 2005, the NAACP had its annual convention in my hometown of Milwaukee. And I spoke following Senator Feingold, where we were supposed to give words of welcome to our city and state and wish everybody well. Well, Senator Feingold did that, and I went a little bit beyond that. I said I was going to try to do two things in the year and a half remaining in my term as chairman of the Judiciary Committee. The first was to overturn the Kelo decision on eminent domain. We're still working on that. And the second was to renew the Voting Rights Act and reauthorize it in the year 2006. And with Mel Watt, we were successful in doing that. Well, walking off the platform, Senator Feingold turned around to me and said, "Jim, I can't understand this. This was my audience, and I got polite applause. It was not your audience, and you got two standing ovations. And what's going on here?" And I said, "Substance, Senator." And with that, we went our separate ways. The other thing I can say is after the 2006 reauthorization, about a year after that, I got a call from a reporter. And this is as the Congress was becoming much more hyper-partisan, and it's become even more so today. And the question the reporter posed to me was, which member on the other side of the aisle do you have the most respect for? And I said Mel Watt. And the reporter's jaw kind of went on the floor, saying, well, he's a liberal Democrat, you're a conservative Republican, you come from a largely white district, he comes from a largely African-American district. Why do you two get along so well? And I said, because we united to reauthorize the Voting Rights Act. We had some really intense negotiations, and I can say that we were literally back to back, with me pushing people off to the right that didn't want stuff done and him pushing people off to the left. And I said we were able to rise above all of the partisanship and have the largest bipartisan vote in the history of the Voting Rights Act, reauthorizing it in 2006. Now, 7 years ago, Republicans and Democrats worked together to reauthorize the VRA. I did not think my congressional career would include a third VRA reauthorization, but the law was as important today as it was in 1982 when I helped broker a bipartisan compromise and then went up to the White House to convince President Reagan to sign that reauthorization, even though his then Assistant Attorney General for Civil Rights, William Bradford Reynolds, who came out of a fine old Richmond law firm, didn't want to see that law on the books anymore. And I'm committed as ever to its reauthorization. Today, we are again tasked with ensuring that Americans are not discriminated against when exercising their fundamental right to vote. America still needs the Voting Rights Act. Signed into law in 1965 and last reauthorized by Congress in 2006, the VRA is one of the most important pieces of civil rights legislation ever passed. Although it was originally enacted to address overt forms of racial discrimination such as literacy tests and grandfather clauses, its preclearance provisions have also prevented states from engaging in subtler forms of discrimination. Otherwise, lawful tactics, including at-large elections, last-minute poll location changes, have been used to discriminate against minority voters. The VRA helped distinguish America as the premier example of democracy in the world. In contrast to past attempts to end voter discrimination, the VRA required federal preclearance of changes to voting laws in areas with documented histories of discrimination. There is no acceptable remedy for an unfair election after the fact. The tainted ballots are either in the ballot box and counted with all the rest of them, or probably more importantly, ballots of people who are legitimately qualified to vote never make it into the ballot box to be counted. Section 5 of the VRA was the only federal remedy that could stop discriminatory practices before they impacted elections. In 2006, the House and Senate Judiciary Committees held more than 20 hearings to examine the effectiveness of the VRA, whether it should be extended, and if so, what the extension should encompass. Congress amassed an extensive legislative record that totaled more than 15,000 pages, documented widespread evidence of then current invidious discrimination, demonstrating the continued need for federal oversight. I do not believe that at any time in history the Congress has amassed a more extensive legislative record than in 2005 and 2006 on the VRA. And as a result, the 2006 reauthorization passed by the largest bipartisan vote in the Act's history. In her dissent in the Shelby County case, Justice Ginsburg quoted me as saying that the VRA was, quote, one of the most extensive considerations of any piece of legislation that the United States Congress has dealt with in the 27 and a half years I have served in Congress. Had she called me when she was writing her dissent, I would have updated that to 35 and a half years. The Supreme Court's ruling in Shelby County versus Holder severely weakened the election protections that we have fought so hard for over the years. In its 5-4 decision, the court eliminated the VRA's formula for determining which areas are covered by Section 5. The result is the preclearance requirement remains, but it no longer applies anywhere except in the handful of locations currently subject to a court order. Unfortunately, the majority's decision failed to account for the bailout procedures in the VRA reauthorization. Chief Justice Roberts correctly recognized that the VRA, quote, employed extraordinary measures to address an extraordinary problem, unquote. While the majority chastised Congress for failing to update Section 4's coverage formula, they ignored the fact that covered areas can bail out of the VRA's coverage. Far from punishing areas for distant history, any covered jurisdiction could bail out of coverage by demonstrating a 10-year period without discrimination. The coverage formula, coupled with the Act's bailout procedures, ensures a fluid and current response to discrimination. The very fact that these jurisdictions have not bailed out is evidence that the VRA's extraordinary measures are still necessary. This summer, I testified alongside Congressman John Lewis of Georgia before the Senate Judiciary Committee about the VRA. One of the highest compliments I have ever received was at the end of the testimony when Mr. Lewis turned around to me and said, "Jim, you are my friend and my brother." I am proud that with all the disagreements in Washington, voting rights still enjoy significant bipartisan support. The House of Representatives reauthorized the VRA in 2006 by a vote of 329 to 24. The Senate voted unanimously 98 to nothing. We have an uphill battle, but I do not believe that politics have changed so much that saving the VRA is impossible. I believe that we can find a solution that addresses the Supreme Court's concerns in Shelby County versus Holder and complies with the so-called Hastert rule, which informally requires support from a majority of the members of the majority party. Voter discrimination still exists, and our progress toward equality should not be mistaken for a victory. There is a constitutional bipartisan path forward on the VRA, and I am committed to finding it. Thank you all for inviting me here. I know that Republicans appear at this forum very infrequently, but I really do appreciate the fact for me to come here to demonstrate that there is at least one Republican, and you'll find out in the future a lot more, that's committing to putting life in this most important Civil Rights Act that got a stab in the back from the Supreme Court. Thank you. God bless you all, and God bless America.
As I said, now, Jim Sensenbrenner is not leaving because he's afraid to answer questions about this. I leaned on him heavily to get him here, and I want to express my public thanks to him for revising his schedule. And tell Ms. Sensenbrenner I said hello. She's my friend, too. Her birthday's coming up this weekend. I think that's why he's got to go. So there are some things in life that are priorities here. So let me bring on next Representative Bobby Scott, who, along with Representative G.K. Butterfield from North Carolina, has been leading an effort on the part of the Congressional Black Caucus to try to figure out how to move forward in the aftermath of the Shelby decision. And I'll ask him to address that. I won't say anything more about him, otherwise I'll be controversial.
Thank you. Give Mel White another round of applause. As Jim Sensenbrenner mentioned, he was primarily responsible for making sure that we substantively got to the reauthorization just a few years ago. So Mel, thank you for your leadership in voting rights. And we'd have no better friend in the Attorney General's office than the Attorney General of the United States, Eric Holder, who has said that the Supreme Court isn't the only one that's supposed to be protecting our rights. If the Supreme Court isn't going to do its job, the Attorney General will do his job. And so all those that, right after the decision, you had states come up and say that, oh, good, now that we are not under pre-clearance, we can pass some of these laws. Statements that make no sense unless you assume they knew that those laws were discriminatory and would not be pre-cleared. And because of the lack of pre-clearance, they could now pass them. If that's all the evidence you need to prove the need for pre-clearance. Pleased also to be here with Cheryl Affle and Anita Earls, two of the nation's leaders in voting rights protection. Supreme Court once noticed in Westbury v. Saunders that no right is more precious in a free country than that of having a voice in the election of those who make the laws under which as good citizens we must live. Other rights, even the most basic, are illusory if the right to vote is undermined. And that's true today as it was back then. The Voting Rights Act was passed, signed into law, as we've heard, in 1965 to protect the right to vote. Since 1965, blacks are now able to vote primarily because of Section 5. Prior to the Voting Rights Act, all these discriminatory schemes and and efforts were effective. Some counties with substantial black populations had virtually no blacks registered to vote. Now, Section 5 is extremely important. It covers states with a documented history of discrimination and low voter turnout. They have to go through pre-clearance if they change any election law. You can't tell in advance whether an election law change is going to be discriminatory or not, so that's why they have to submit all of them, even some that look innocuous. Oh, they just moved a polling place. Yeah, from downtown where it's accessible to a segregated country club. You know, some of the things that look innocuous, when you start looking at it, everything needs to be pre-cleared. The Section 5 states, those who are they were covered for pre-clearance, were covered the way I describe it, and old people will know what I'm talking about. They were selected the old-fashioned way. They earned it. Now, for those under 50 years old, there was a TV commercial where a financial executive was saying that they make money the old-fashioned way, they earn it. And so these guys got covered the old-fashioned way. They earned it. They had poll taxes and all kinds of literacy tests that could not be passed by PhDs, and they were effective in essentially making no blacks eligible to vote. Now, because of Section 5, those laws changes cannot go into effect. So if they want to change and make things worse, they don't get pre-cleared, it doesn't go into effect. And just look what happens if you don't have pre-clearance. They come up with some scheme, and on a statewide basis, you can protect yourself. But what about this little local school board, where in a small county, where the NAACP has about $83.50 in the Treasury? What happens when they come up with a redistricting scheme or something and want to put it into effect? Without pre-clearance, it goes into effect. And the victims have to first study it and evaluate it and pay some money to have somebody prove that it's discriminatory. Then once they've got the idea that it is in fact discriminatory, now they got to hire a lawyer with whatever money, I don't know, to go to court. And by the time they get to court, and finally get a ruling that it is in fact discriminatory, look what happened. The people got elected, they have been ruling, they have been legislating, they have been spending your money, and then when they finally determined it's illegal, now they get to run as incumbents with all the advantages of incumbency. The beauty of Section 5 is that scheme never could go into effect to begin with. And that's why we need to preserve Section 5 and why this decision was so troubling, because it essentially, by eliminating the formula by which you determine which were covered, and they made that unconstitutional, now nobody's covered. There's essentially now no Section 5, and these states are free to do what they want. Now we're gonna fix it. You heard from Mel Watt, you heard from the Attorney General, you heard from Jim Sensenbrenner. We're gonna fix it, and there are a lot of little things that we have to fix. First, Section 4, the coverage. Who will be covered? Now, we got to recognize that we lost the case. The number of states that have covered today, we're not going to be able, consistent with the Supreme Court ruling, to cover as many as we want. But we can go back, and there are a bunch of them that have violated Section 5 and been caught trying to discriminate, or Section 2 had something in effect that had to be set aside. We can come up with one list. But after that little initial list is there, we need to beef up Section 3. That's the bail-in and bail-out provision. Now, Jim mentioned bail-out. If you have behaved yourself and haven't discriminated for a few years, you can go and ask the court to let you get out. People have been bailing out right and left. The day before the decision, Hanover County in Virginia got bailed out. So that process is working. A lot of people haven't taken advantage of it, primarily because a lot of people don't want to take advantage of it. Some jurisdictions like the fact, just for race relations, so they don't have to deal with a bunch of argument when they have an election change. The Justice Department tells them it's okay. So they don't have to worry about arguing about why'd you do this, why'd you do that. They may not like it, but it was not discriminatory because the Justice Department told them so. And maybe that's something they don't want to get out from under. But the the bail-in is if you are in court discriminating, we need an easier process than we have now to get you bailed in. So those who are violating the law in the future get bailed in. The list with bailing out and bailing in will be kind of evolving over time, and that will solve the major problem that the Chief Justice articulated, that it's a 40-year-old formula. Well, this will be an evolving formula, always up to date. We also have to deal with Section 2. Since we don't have preclearance, if you file a Section 2 case, you have to have an easier shot at getting an injunction, so these things do not go into effect. And finally, let me just say Section 5, even if you are not covered, I think there are a lot of jurisdictions that would like the Department of Justice to review a redistricting case or some other change, just to have it blessed as not discriminatory at federal expense rather than at local expense, so that just for race relations you can say, well, we have to have a redistricting, but we're going to submit it to justice for evaluation to prove that what we have done is not discriminatory on a voluntary basis, even though they're not covered. We might want to consider that. But whatever we do, unfortunately, we lost the case, so it's not going to be as good as what we had. But we have to get Section 5 back in business, because otherwise these states that have been bragging about the fact that they now can pass these discriminatory laws need to be stopped. Thank goodness we have an Attorney General who's stopping them under Section 2, but we need also to stop them under Section 5. Thank you very much.
Thank you. The Attorney General said the Congress needed supervision, so he stayed long enough to give us supervision. So he's going to leave us now. And let's thank the Attorney General once again for his presentation and for the magnificent work he's doing in this area. Thanks so much. And Bobby's going to leave us temporarily, but he'll be back to participate in some discussion with us. So let's move now to the third area that I talked about. We've got some wonderful, wonderful legal experts in this area who are going to talk to us. And the first one is Sherilyn Eiffel. She's the 7th president and director counsel of the NAACP Legal Defense and Educational Fund, following in the footsteps of legal giants like Thurgood Marshall, my former law partner and mentor, Julius Chambers, who passed away earlier this year, and Elaine Jones, who will be honored at tomorrow night's dinner gala. Immediately prior to assuming her current position, Sherilyn was Professor Eiffel, a tenured professor at the University of Maryland Law School. Sherilyn taught civil procedure, constitutional law, in a variety of seminars, and continued to litigate and consult on a broad and diverse range of civil rights cases. She started her legal career at the ACLU before joining the staff of the Legal Defense Fund, where she litigated voting rights cases, including the landmark Voting Rights Act case, Houston Lawyers Association versus Attorney General of Texas, in which the Supreme Court held that judicial elections are covered by the provisions of Section 2 of the Voting Rights Act. Sherilyn is back at home now, leading the organization where she cut her teeth and grooming the next generation of civil rights lawyers. She brings a wealth of experience to this area of the law, and we're fortunate to have her joining us today. And so I'll bring on Sherilyn. And then, or should I go on and I'll introduce Anita Earls, and then she'll follow right behind Sherilyn. Anita Earls is a founder and executive director of the Southern Coalition for Social Justice, which is based in Durham, North Carolina. She's a civil rights attorney with over 25 years of experience litigating cases, many of those years litigating cases in which the subject was the 12th Congressional District of North Carolina, which is the one that I represent. From 1998 to 2000, she was Deputy Attorney, Assistant Attorney General in the Civil Rights Division at the Justice Department, where she was responsible for supervising several sections, including the division's voting section. Anita has taught at the University of Maryland Law School, the University of North Carolina Law School, and at Duke University. She's also my former law partner with the law firm that Julius Chambers founded in Charlotte, North Carolina. And we practiced together for a number of years before I came to Congress. In fact, some people say I recruited her to the firm. I've heard a different version from her of that, so I'm not going there. At the law firm, she litigated a variety of civil rights cases in private practice, including school desegregation, employment discrimination, and voting rights. She was a key advisor and advocate during the reauthorization of the Voting Rights Act in 2006, and has worked on some of the key cases that made their way to the Supreme Court in the years following reauthorization. And I am delighted that she has joined us to talk about some of the approaches, legal and to the legislative arena. So Sherilyn, if you'll go, and then followed by Anita, and then we'll try to open this up hopefully for a little bit of discussion at the end.
Thank you very much. Let me first just begin by thanking all of you, but especially by thanking Congressman Watt for inviting me to participate in this discussion today. I am really just thrilled and absolutely honored to be part of this panel. I really just kind of bow before you. You are the dean of the reauthorization of the Voting Rights Act.
It just means I'm old.
Oh, no. And of course, Representative Bobby Scott as well, who's just got such a brilliant mind and is so focused, has such a laser-like focus on the set of issues that we're dealing with surrounding the Voting Rights Act. And of course, so thrilled to have with us earlier Congressman Sensenbrenner, whose really extraordinary leadership in this area, I think, speaks so well to the issues that are before us, the importance of voting rights to the character of this country, and his willingness to stand up immediately and to express his desire to engage in the fight, I think is tremendously encouraging to all of us. And of course, the Attorney General, whose remarks I thought were excellent, and who really from the day of the decision, we went to his office the day of the Shelby decision, and he was standing at the ready, and he had prepared his troops, and he had no hesitation in his response that voting rights would continue to be protected in this country. And I would be remiss if I didn't also give my own personal just moment of acknowledgement and honor to the man whose name this session is named for, A. Leon Higginbotham, the late judge. I worked for him as a summer intern, my first summer in law school, and he was a mentor and a great leader for me and an inspiration, as was Julius Chambers, who was a former director counsel of the NAACP Legal Defense Fund, was the man who hired me as a young lawyer at the Legal Defense Fund and who shaped me as a civil rights lawyer. So lots to honor today. Also a bit of dishonor, and that is the reason that we're here today. We should be embarrassed as a country that we have to even have a session like this in which we talk about, for I don't know what iteration it is at this point, once again returning to the table to ensure that the right to vote is preserved for everyone. It was the Supreme Court that said that the right to vote is both fundamental and preservative of all rights. And this year, the Supreme Court turned its back on that essential truth. And it's one of the reasons why in my conversations about what we're doing this year, I came on board to lead the Legal Defense Fund in January, and so there's been lots of discussion about, what's the civil rights agenda. I have been insisting that our conversations about this issue, about the Voting Rights Act, cannot be shunted into a corner and just called civil rights. We are in a democracy moment in our country. And the path before us is really a crossroads. Which direction are we going to go in? Are we going to go into the direction of inclusion, of expansive civil rights, of expansive engagement and equality, or are we going to turn our backs on the great promise of this country? And that's something that everyone should be engaged in, not just civil rights lawyers or civil rights activists or even just the Congressional Black Caucus. So we're at a critical moment. I want to say a few words about the decision. Then I want to talk about what we've seen on the ground as the immediate reaction to the decision in communities all over this country. Talk about then what we lost and therefore what we need in whatever is the fix. So first of all, you should know that the NAACP Legal Defense Fund represented black voters from Shelby County in the Shelby County, Alabama case. We litigated that case, we argued that case, and in fact, the man who argued on behalf of black voters in Shelby County is here today. Debo Adegbile is sitting right there. Yes, you can clap. And so we feel this case pretty keenly. We have read the decision probably more times than is healthy. But I think it's actually been useful to read it all over and over again, largely because in my view, the more you read it, the hollower it becomes. And it really stands on a very shaky, shaky table. I wouldn't even call it a three-legged stool. But nevertheless, as Representative Scott said, we lost the case. And we lost the case because of the Supreme Court's determination and their own, frankly, personal intuition that we have reached a moment in this country in which racial discrimination is no longer something significant enough that we have to engage in certain kinds of action to remedy it. Yes, I know they said that racial discrimination in voting still exists, and I know that they said that you just have to go about it a different way, but underlying the decision is the court's intuition that this just isn't necessary. And it's important for us to face that because as we go through the process of hearings and developing a record for the amendment to the Voting Rights Act, we have to recognize that we have to overcome that intuition on the court. Yes, back? Now, that intuition, unfortunately, is not informed by fact. It appears to be just a hunch. And that's good news for us because the facts are on our side. The facts are on our side because of the record that was developed certainly in 2006 for reauthorization, which you've heard a great deal about. But the facts are also on our side because within hours of the Supreme Court's decision, officials in jurisdictions all over the country, particularly in the South, began immediately to declare their intention of imposing measures that have been deemed to be discriminatory because they are now free from preclearance. The Texas Attorney General, as you know, was the first out of the gate, 2 hours after the decision, tweeted his intention to impose the Texas voter ID law. This was a voter ID law that LDF and the Department of Justice had litigated and fought against in 2012 successfully, and it had been stopped because of Section 5. And now with the removal of Section 5, something that could not have been done 24 hours earlier, the Texas Attorney General announced his intention of imposing that law. And you know that that law has in fact gone into effect. The Attorney General has sued about that law. We also have intervened in that lawsuit, and I'll talk a little bit about that in a moment. The Secretary of State of Texas said, we're free and clear now. We're free and clear now. And a host of other officials in jurisdictions throughout the South declared their intention to impose discriminatory voting measures. So those are intentions, and some of them were rumors, and the question is, what do we as civil rights organizations do with that? And I have to tell you that the removal of the protections of Section 4 and the hollowing of Section 5 has imposed an enormous burden on organizations like mine and Anita's. What Section 5 used to give us, the early warning system, right, of voting changes that might be discriminatory, was removed with the stroke of a pen. A 48-year protection was gone. So that means that when we hear that something is happening, we have to go and investigate. We have to find out, is it true that this action is taking place? Is it not true? That means we have to go down and train people in the community and train local lawyers to identify properly what these voting changes are. And we had to begin to get the word out to people that you got to start attending all of the community meetings and the election board meetings and the school board meetings so that you now are the eyes and ears to find out when these changes are happening. And so we spent a great portion of the summer just traveling throughout the states that we work in the South, talking with community leaders and community groups and preparing them so that they can furnish us with the information that we would need to engage in litigation. Because of course the Supreme Court did not strike down the Voting Rights Act. There are still provisions of the Voting Rights Act that exist. And we now have to prepare lawsuits, and we need the information to do so. So we run down rumors, we investigate claims, and we've seen a great deal. One of the things that has been percolating in jurisdictions all over the South is something that we thought we had put to rest quite some time ago. And that is the intention to return to at-large voting in jurisdictions all over the country. At-large jurisdictions or voting by at-large jurisdictions are when the whole county or the whole city votes for a particular set of offices rather than by district. And for many decades, we fought against at-large voting because of the way in which it undermines the ability of minority voters to elect candidates of their choice. And now you have jurisdictions all over the South that are talking about returning to at-large elections. Now you heard Representative Scott talk about jurisdictions when he was up here, and I do want to emphasize this point, because what makes this so challenging is the number of micro-jurisdictions, political jurisdictions that exist in the United States. We're talking about the school board districts, the municipal districts, the water districts, the utility districts, the justice of the peace districts, the county council districts, the city council districts. These are the things that don't make it into the newspaper, that won't be in the Washington Post, that won't be talked about on television at night. But these are the micro-political jurisdictions where power is exercised over the lives of racial minorities all over this country. So the challenge for us is to find out at the micro-district level what's happening. I just got back a couple weeks ago from Albany, Georgia, visiting Shirley Sherrod, who many of you know is an amazing civil rights leader and activist. And just days after the Supreme Court decision in Baker County, the election board decided that they should close 6 of the 7 polling places for next year's election. This is in a rural county that'll require voters to drive 20 to 25 miles to vote. So you have to get down to that level, and we're expending a considerable amount of our resources doing that and preparing litigation. As I talked about, we also intervened in the Texas voter ID suit. We had represented students in that suit, that students who can no longer use their student ID as ID to vote, but if you have a concealed gun carry permit, you can use that to vote. So we'd represented students in 2012, and we were successful, and we still represent those same students who used their student ID in the 2012 election and now can't. And so we're participating in that litigation. And we've got about 5 or 6 other cases that are teed up, waiting for the action that we've heard is going to happen to take place. The truth is that we're going to see much more of this action as we get closer to 2014. In many places, we're in an off-election year. And many of you will recall that in 2012, we started to see a lot of mischief happening around early voting and so forth as it got closer and closer to the election. So we are also preparing ourselves for what we expect to happen as we get closer to 2014. So lastly, I want to talk about really what we lost and therefore what we ought to be kind of looking to in a renewed Section 4 and hope that we'll have a chance in our dialogue to talk about it. One of the things you've heard about already is the early warning system of Section 5. That is, the Section 5 allowed you to hear about voting changes before they happened because a jurisdiction had to submit the voting change to the Department of Justice. And as I suggested, now they don't have to do that, and we have to find out about it. We find out about it by relationships with community groups. But the reality is my organization, Anita's organization, all the civil rights groups put together with the Department of Justice lawyers could not possibly find out all of the changes that are happening at the micro-jurisdictional level for all the jurisdictions that were formerly covered by Section 5. Just not possible as a matter of manpower. So some things will slip through the cracks. So we've got to figure out a way to have that early warning system back. The idea of stopping the discrimination before it happens, which you heard Representative Scott talk about as well, all of the ways in which when you allow the discriminatory system to go forward, it benefits those who are elected under the discriminatory system, and you can't really unring that bell because that person now does get to run as an incumbent, has the war chest, has the experience, and so forth. And so figuring out a way that we can make sure we stop it before it happens. As we've been, teeing up as civil rights groups for litigation under Section 2 of the Act and looking at bail-in, using litigation to bail-in jurisdictions, it's important to remember that this is all going to court, filing cases, and litigating. Now, we're a civil rights law organization, so that's our meat and potatoes, that's what we do. But, it probably sounds weird to say it's not like that's what we want to do. I mean, ultimately, we would like to be out of business at some point. But more importantly, we would like to be able to resolve civil rights legal claims without having to go through the expense of litigation and the time of litigation. And Congress wanted that too. That's why Congress reauthorized Section 5 and Section 4, because the truth is Section 5 allows you to avoid litigation. And what I think many of the jurisdictions will begin to see is that this is not working for them either. Because as we begin to roll out our litigation, and we've all been talking with each other and coordinating with each other, and we start rolling it out, some of these little jurisdictions are going to discover that they're not ready for this fight. They're not ready for it financially, they're not ready for it as a matter of manpower. So avoiding the need to litigate every change is critically important. This is not what Congress wanted. Congress enacted Section 4 and Section 5 for the express purpose of having an administrative preclearance procedure that would be quick and would be cheap. Litigation, we can do it well, but even when we prevail, it can take 2, 3 years, 4 years before you prevail. So somehow, as we begin to look at what's going to be the fix, we've got to put our mind to what we've lost, and then we've got to figure out how we can regain what we've lost with a pragmatic view towards what Representative Scott has said, we lost the case, and with a pragmatic view to the modern reality of how voting discrimination plays out on the ground in jurisdictions throughout this country. So I'll stop there, turn it over to Anita, and hope in our dialogue we can talk more about it. Thank you.
Good afternoon. I am truly honored to be here today. I especially want to thank Mel and Stephanie for giving me the opportunity to come and speak to you sort of from the belly of the beast, North Carolina, and for recognizing that that a local perspective and talking about what we can do in our communities is an important part of the dialogue on what we should do legislatively on voting rights. And of course, I'm also amazed to be on such a distinguished panel. Representative Scott, many of you may not know, he invited me to come to Virginia and litigate following the 2000 round of redistricting, a little case called Hall versus Virginia that I promised him we had a chance of winning, and we lost. And he still shakes my hand. So I am truly honored to be on a panel with him. Sherilyn, I've said many times, has been a longtime mentor, friend, colleague, and so here I am with people that I admire so much, and I'm just really overwhelmed. I did think a lot about Judge Higginbotham in thinking about what I wanted to say to you today, and it has actually been 15 years since he died. And so I can imagine him coming back. I got to work with him on the Shaw case and got to see his brilliance and his tenacity and just his fight, the fight in the man. And I imagine he would come back and say, well, you've had 15 years, what have you achieved? Right? We've been fighting for voting rights, what have we done in 15 years? And what I'd like to say, right, what I'd like to tell him is that everyone votes now. Felons, students, homeless people, we have made it so easy to vote. Everyone votes in our democracy. I'd like to tell him that we have a right to vote now in our Constitution. I'd like to tell him that governing bodies at all levels reflect the diversity of America in the viewpoint and the experiences of the people, and that those representatives, that people actually hold them accountable, that they're answerable to the diverse communities that we have in this country. That's what I'd like to tell him. And of course, in truth, what I'd have to tell him is that we are facing the biggest assault on our voting rights that we've seen since before 15 years ago. This is a more serious attack against the fundamental right to get access to the ballot and vote that I've seen in my career. And you know, you can understand why this is happening now. As communities of color are growing in this country, and when the folks, the people opposing them are now in some places numerically in the minority, but they know over time they're going to be in the minority. And if you are numerically in the minority, the only way you can keep power is to keep those folks from voting. But it's not just, I would submit to you, not just policymakers and politicians who have this idea that there's some party of the electorate that we should keep from voting. It's pervasive. This week, in the Raleigh newspaper, a letter to the editor is responding. There was a previous letter saying, let's have universal voter registration. The response to that was a letter saying, you know, the electorate is not very intelligent. People don't even know who their elected officials are. And the conclusion was, and I'm quoting now, we need far, far fewer people to vote and should encourage them to stay at home on election day. There's really a sense out there in the public that, you know, voting's not a right that everyone has, everyone should exercise, but that somehow it's a privilege and only certain people should be able to do it. So how do we respond to that? The other thing I would tell Judge Higginbotham is that while we're facing the biggest attack we've ever faced, I also see an amazing resurgence of people on the ground dedicated to the right to vote. In the Moral Mondays movement in North Carolina, we have people going to jail, and when reporters come up and ask them, well, why are you going to jail? They say, because my right to vote is under attack. And that's also something I haven't seen in the 25 years I've been doing this work. So that we can take hope from. And so beyond the legislation, I believe too that Congress will find a way to fix the coverage formula and get Section 5 back in the places where it's needed. The role that the Department of Justice is playing is important. I hope that they come to North Carolina next. I hope they come to all of the states where they're needed to do what they do. But there's also a need for all of you. In fact, my one takeaway, the thing I want you to remember from my remarks, is that in this time, you are the new DOJ. You are the eyes and ears on the ground to know what those changes affecting voting are and mobilize to try to stop them. So I'm going to give you a couple of examples, but the other thing I want to tell you is that learning where these decisions are being made. Do you have a local board of elections? Is there a supervisor of elections? Is that the Secretary of State? How do you monitor that? What other avenues are there besides going to federal court? In Texas, for example, you can file an administrative complaint with the Secretary of State if you have a grievance over how voting is being administered. There are a lot of state and local remedies that we can begin to use more actively. So 2 examples from North Carolina. Most recently, the Elizabeth City State University campus had been registering a lot of students. And you may have heard about this in the news. 56 students were thrown off the rolls by the local board of elections. And then a student body president said, I'm going to run for city council. And the local board said, no, we don't, because you live in a dorm, we don't think you can vote. And they disqualified him from running. And he stood up to that. And students organized, they mobilized, and the state board of elections, in the face of, crowded, they had overflow, they couldn't hold everyone who came to the hearing. And they were also wrong on the law, because college students absolutely do have a right to vote in the dormitory, if they are resident in their dormitories and they register to vote there. And that's been established by U.S. Supreme Court precedent, as well as it was true under state law. But What made the difference there was that someone was willing to stand up to this local board of elections. They have since backed down. We still are expecting problems in our October elections. Students are mobilizing to monitor at the polling place, but a lot of this is happening at the local level. Another example in Watauga County in North Carolina, where the local board of elections, in a hastily called meeting where they had met before and decided what they were going to do, consolidated 3 precincts into one huge precinct that would have 9,000 voters. Couldn't possibly handle that volume on election day. And people organized to fight back against that. They came to, they packed that local meeting. They then went to the state board to protest it. And it's not fully resolved yet, but they're backing down from that. So when people stand up in their local communities and say, no, the right to vote is important and we all have to fight for it, it really can make a difference. Southern Coalition for Social Justice is having an hour-and-a-half webinar along with some other partners. Southern Echo, Leadership Conference on Civil Rights is a partner. This is going to be next September 25th, next Wednesday, 2 p.m. to 3:30. It's a free webinar. If you go to our website, you can register for it. Website's www.scsj.org. So we'll give you a lot of ideas about how you can be the new DOJ in your community, monitor what's going on, and take action to stop voter suppression measures. The other thing that I want to talk about just briefly is the litigation that we are engaged in, because when these new voter suppression measures are passed, you've heard a lot about voter ID, and North Carolina, is leading the country now in the most restrictive voter ID bill. There's actually more forms of ID that you can use to get a gun permit in North Carolina than you can use to vote. Student IDs are not acceptable. You have to have an in-state driver's license, and there is a discrete part of the population who simply can't get an ID. We represent a woman who, Mrs. Curry, who is 78 years old. She was born at home with a midwife. She doesn't have a birth certificate. She doesn't drive. She's disabled. She can't get a state-issued ID. And when you hear her talk about why it matters to her, she could vote absentee without an ID, but if she wants to vote in person, she needs that ID. She talks about how the first time she voted in 1956 in rural North Carolina, the black folks had to wait so if whites came in after them, they went to the front of the line. She said it was an all-day thing, right? They had to spend all day to finally be able to vote. And that was, and of course, there was a literacy test. And so since then, the ethic in her family is you don't miss a voting day. Right? And she's the first one in line at her precinct when early voting starts, because it matters to her to be there in person and to see her ballot run through that machine. She says, I want to see my ballot counted. So it is a matter of fundamental human dignity that she should be able to participate in our democracy at the same level as everyone else. So that's why we're fighting voter ID. We're also fighting the cutbacks to same-day registration, which will impact a huge number of people who move and forget to re-register, people who don't realize that they had to register 30 days before the election. There will be a lot of people impacted by the cutbacks in North Carolina on same-day registration and some of the similar attacks in other places. The moves to limit early voting. The early voting period in North Carolina was cut in half. And we showed, when these bills were being considered, that these would disproportionately impact voters of color, that African Americans more often use same-day registration, more often voted early. The third thing they did was change how they count out-of-precinct provisional ballots. And I won't go into all the details, but that was another measure that allowed ballots of people of color to be counted. And the legislature said, we don't care, we're passing this anyway. So we are hoping to expand jurisprudence under Section 2 of the Voting Rights Act and show that when you enact these kinds of measures, you are violating the Voting Rights Act and the courts must step in to stop it. So I want to, in concluding, talk about what happened after 1986. 1986 was the Supreme Court's decision in Thornburg versus Jingles, and it showed how you could establish a vote dilution claim under the Voting Rights Act. And it said you no longer have to prove intent. There had been other cases that said you have to prove that this redistricting scheme was put in place intending to discriminate. And in Thornburg, the court said, no, if you can show that it has a discriminatory impact, then you can require a court to give you a new method of election. Throughout the South, across the South, lawyers in North Carolina, South Carolina, Virginia, Mississippi, Texas, Florida, went to court, local lawyers went to court filing Section 2 cases to end the use of at-large elections at the local level for school boards, county commissions, city councils. There's a wave of litigation. And it was a great time to be a voting rights lawyer. I started in 1988, and we would go to seminars and say, we're going to win these cases. We don't even have to litigate. The other side will settle because the law is so clear. And I think part of the key to why that was so successful was that we had so many local attorneys working with their local communities, tied to what was going on and able to have an impact. And that's what I submit we need now. We need to reinvigorate our Section 2 litigation, have local attorneys in local areas ready to go to court quickly when someone's trying to knock someone off the voting rolls when they shouldn't, or when someone's trying to move a polling place, or engage in these kinds of practices. And I think that it was successful then, and we can reinvigorate that. And so finally, let me say what you can do. So I'm talking about what we need to do as a community. What can you do as an individual? Obviously, you have to help voters get registered. If there are changes affecting voting, learn the new rules. There was recently, last week, a poll in North Carolina, and a third of voters didn't even realize that the voter ID law had been passed. So there really is a big public education effort that has to go on. It just can't be business as usual in our democracy right now. We need everyone to be taking these actions. If you live in a state that has a voter ID requirement, helping those people who don't have an ID, helping them get an ID is a really valuable and important thing. And it might sound easy. We know from the Pennsylvania experience that a year ago, 328,000 people don't have an ID in Pennsylvania. After 1 year, only 17,000 people were issued IDs. That means 95% of those folks still don't have a voter ID. So it really will be hard work, and each of you can make a difference. In some cases, helping voters get an absentee ballot might be the best solution, and of course, helping people vote early. So there is a lot that you can do to make a difference, and I really appreciate you being here today and hearing from all of us. Thank you.
Will you join me in thanking all of our panelists, some in absentia now, and those who are still here So we've got about 30 minutes now, and we're going to get to a dialogue, but I want to, so there's a microphone here. If people have questions, or comments, short comments, mostly questions, I encourage you to go to the mic. But let me do a couple of things before we go to questions and answers, because we may start to lose people. There are some takeaways here that I think I don't want anybody to miss. When pre-clearance of voting changes was required, every voting change in the covered jurisdictions had to be submitted to the Justice Department for review and approval. The Supreme Court said, no, that's not going to happen anymore. And so I don't want anybody to miss the point that was made that the Justice Department is not going to be able to play that role anymore, and that imposes a special burden on every single one of us in our local communities to become what Anita referred to as the Department of Justice. You've got to play the role of Attorney General. And you've got to stay abreast of the changes that are being made, regardless of how minor they are. You need to be looking at them and understanding the impact that they have on your ability to vote. Not only your ability to cast a vote or show an ID or not show an ID, but on how inconvenient it makes it for minorities to vote. A closing of polling places, a consolidation of precincts. If there is an inconvenience, that makes it more difficult, and you've got to play that role now. The second takeaway that I don't want you to miss is that this is going because the Department of Justice has stopped a bunch of bad things from happening before they happened, and they are now going to happen without the Justice Department being involved. This is going to result in a lot more litigation. And there are some organizations that are standing in the gap to litigate those cases, right? The NAACP has been standing in the gap to identify a lot of the changes, and you need to be getting involved with them on that front to do that. But the NAACP Legal Defense Fund and Anita's organization, the Southern Coalition for Social Justice, and other organizations of that type are going to be deluged with requests for litigation. I mean, let's just be honest about it. And that is going to be a heavy financial burden. So, in Charlotte, we have a big dinner for the Legal Defense Fund to raise money every year. I mean, I can't stand here and solicit money, but you need to be more committed to supporting the organizations that are standing in the gap between us and the loss of our vote and the loss of our voting privileges. Anita's organization is having a fundraiser today after she sent me an email about it. She didn't ask me to do this, but I'm telling you, don't just go over there and drink up their liquor now. Go over and support them at Bar 7. Let's see. Across from the convention center, I don't know where this is, 1015 and a half 7th Street Northwest at 5:30, right after this, we need to,
And I'll just take checks right here.
Yeah, and Sherilyn will take checks right here. I mean, this is going to be a heavy burden on our community that the Justice Department has been deflecting a lot of these cases, and they are not going to be able to stand in this gap for us anymore. This is a major imposition that the Supreme Court has thrust upon us. So I want to encourage you to be generous with these organizations that have stood in the gap and continue to stand in the gap, because the burden on them is going to be heavier and heavier and heavier. And then finally, I want, before we get to general questions, I want at least Bobby to to reflect for a little bit on how confident he is that we will find a new coverage formula that the Congress will pass and that the United States Supreme Court will accept. I mean, you know, one of the concerns I have is if you've done 15,000 pages of documentation to document something and the United States Supreme Court says you didn't do enough, how do you ever do enough
Include Massachusetts?
for you know? So, Bobby, if I need you to talk about that a little bit and what might be necessary to build a record, even if you can stay at your mic there if you want. I think those are active. So let's start with that question, and then I'm coming directly to you.
Well, thank you. Give Mel another round of applause, because he's really the leader in all of this. Figuring out something that the Supreme Court would accept and that could pass is going to be difficult. You start off with a challenge, what the Supreme Court would accept. Part of the problem with the case, and we have to be cautious, is that we're talking about Section 4 having a coverage formula for Section 5. The court went out of its way in the majority opinion saying it had not decided the constitutionality of Section 5. So we can go through and get a Section 4 coverage formula and then say on second thought, we don't like Section 5 either. They essentially dissolved it by nobody covered. So we have that, toss that into the mix. I think the members I've talked to give you the sense that on the Republican side, that this isn't anything, fixing the Voting Rights Act isn't their highest priority, is not their highest priority. But fighting it doesn't sound like it's a high priority either. So if we come up with something reasonable, I think although they may not be particular about it, they don't want to pick this fight if we pick something reasonable. Now, if we get a little greedy, they may pick the fight. And as you know, in the House, there are more Republicans than Democrats, so if the Republicans pick a fight, we lose. And so I think we can make a substantial fix without getting greedy. And although there are a couple of Republicans that might be, as Jim Sensenbrenner might be, there might be a active priority for them. Most of them, I think, if it's a reasonable bill, might well go along. I think you've got to reemphasize the cost of litigation without Section 5. And there are a couple, I don't know, I regret I had to walk out. A couple of problems with Section 5 is the burden of proof on such Section 5 is with the state. You got to prove that your change, or the locality, you have to prove your change is not discriminatory. Under Section 2, when you bring your lawsuit, the burden of proof is on the plaintiff. You have to prove your case, you have to prove the discrimination. It's not only in the litigation, it's also in the evaluation. Who's going to spend the money to ascertain whether the change was discriminatory or not? That costs money to do a retrogressive arithmetic analysis to ascertain whether or not the minority community is disadvantaged by the change. That takes money. Under Section 5, all you got to do is write a letter to the Justice Department and say, this looks suspect to me. I don't know. Put a little stamp on it, and that's it. Under Section 2, you have to show in court that you have done the analysis, and then you get to spend the money on all the proceedings. So Section 5 is extremely important, and I think if it's fixable, we have some bipartisan support, essentially with Chairman Sensenbrenner, and if we do a reasonable bill, I'm confident that we can get it passed.
Yes, sir. Now, please state your name, where you're from, and ask your question.
My name is Royce Akbar. I'm an attorney with Fair Vote. Actually, the gentleman behind me indicated he had a follow-up and asked me if I'd be willing to trade places with him. So I'm just going to switch places with him in line. No, you're okay? Okay, all right. Well, in that case, so Anita mentioned that Section 2 deals with vote dilution. I just wanted to point out real quick, and real quick comment and then a question. There are already 2 votes on the court right now, Scalia and Thomas, who have indicated in writing in a concurring opinion that they do not think that Section 2 supports vote dilution claims at all. So there was some talk about whether the court would take aim at Section 5. There's also at least 2 votes on the court right now that would weaken Section 2. So in the context of vote dilution, I wanted to ask the panel what they thought about proportional representation systems and whether they would be adequate remedies for vote dilution claims, whether litigants should pursue these sorts of remedies, PR remedies, and whether there can be anything done with the act itself that could advance the idea of PR being a good way of addressing vote dilution. Thank you.
I'll take the first stab. I have actually tried in voting rights litigation years ago in Texas and also in Maryland to advance proportional representation as a remedy. And there was really an effort, I think, by a number of lawyers to try and kind of move that center stage in the late 80s and early 90s. We were all unsuccessful for a variety of reasons, and I think the clamor for that has kind of died down. I mean, I think we have to be really careful, just hearing what Representative Scott was saying about not becoming greedy. I think we have to have laser-like focus on what we're trying to get out of this reauthorization. Your point's well taken about, Scalia and Thomas and vote dilution, but I mean, I could give you a laundry list of things that Scalia and Thomas agree on that I think most of us would not believe is on the table. I do think that there's a certain kind of discipline that we have to exercise and engage over the next few months in this process. And that's why I'm trying to suggest that we have to stay focused on what are the essential things we need in order to create a regime that allows us to have the kinds of protection that we had under Section 5. It won't be an exact mirror. And that we ought to really be clear about what is it we lost that's essential, that puts us in the situation that Mel and that Anita were describing, and how do we get those elements back? They may not be the same as they were. And that we have to be very careful not to go too far afield, frankly, largely because of what you said, because, they're going to come for Section 2. There's no question about it, that plan is afoot. So I think we want to be very careful about what in this process we put on the table as we try to seek this amendment.
Did you have a response? I can just tell you, I was early in my career, I was a real advocate for proportional representation. I guess over time I've become more practical. It can be done under the Constitution. The problem is getting states to buy into that as an approach is a problem. And if we're trying to find a practical solution here, putting something else on the table that has historically been impractical, it just doesn't seem to me to be the time to do it. So, anyway. Yes, sir.
Yes, my name is Asa Gordon. I'm chair of the D.C. State Agree and Electoral Task Force. William P. Jones was offered, the book, and I encourage people to Google it, The March on Washington, Jobs, Freedom, and the Forgotten History of Civil Rights. And he's a specialist in history and race relations and specifies a lost motive behind the march that was ignored and forgotten, he said, in the 50th anniversary of the march. And he says, he declared in a change with Amy Goodman on Democracy Now! That a central demand of the March on Washington in '63 was to limit congressional representation in any state where citizens were deprived the right to vote, unquote. Now, pending in the court right now is Gordon versus the clerk of the House of Representatives. I am the Gordon. The judge has said in my case, Mr. Gordon raises some weighty issues having to do with the consequences or results of an electoral system where a minority number of votes are not recognized. That is, when there's a winner-take-all system. The suit is against focus on the state of Georgia. It does not have a winner-take-all state statute. Neither does North Carolina, neither does Alabama, but they do it just as a matter of practice. The suit says if you don't have a state statute that the governor and the Secretary of State can point to that says in our state we award our electors on a winner-take-all basis, you must do it in proportion of the popular split. That means that we would get a minimum of 7 electors out of Georgia in the next election. We would get a minimum of 7 out of North Carolina and a minimum of 3 out of Alabama, because there's no state law that the governor or the Secretary of State can point to. And if they don't do that, you know where I'm going. It is, as this author said, was a demand of the March on Washington that we have forgotten. They included the right to vote and forced the 14th Amendment by reducing congressional representation from states where citizens are disfranchised in proportion to the disfranchised population. This is pending now. I could use some help.
Okay, we appreciate it, and sounds like you've got some help there, right? The guy who was in front of you who believes in proportional representation. I actually agree with you, but you know, whether it's practical or not is a whole different question. You and I have been debating that issue for, I think, the last 5 sessions that we've had this session. You've raised that, and I don't know what we can do about it.
I think you raised talking about two different issues. It sounded like you're talking about the winner-take-all electoral college allocation.
It's both. The reason why.
And then the other is.
Don't start this.
I talk to you.
Okay. Talk to whoever you want to afterwards, but let's try to get through the line. We're running out of time here.
Good afternoon.
Yes, sir.
My name is Reginald Reddy. I have a quick comment and a question. My comment is I was, maybe this is for the future, have, like the people that were from the Department of Justice, like the Attorney General and other congressmen that were on the panel, I wish they could have stayed for the Q&A, for that dialogue with the audience, attendees on a subject so important as voting rights, something that impacts my life and the lives of my relatives I have down south. My question is, given that backdrop, how realistic are the prospects to reauthorize the Voting Rights Act in this session of Congress? That's my question. Thank you.
Well, of course, the Voting Rights Act has been reauthorized. The Voting Rights Act is reauthorized. There was the pre-clearance section that was set aside. So are you asking how realistic is it that we'll get a new pre-clearance formula? That's essentially the same question I asked Bobby Scott.
It's the same question, and I think, let me just add to it, the goal is to get it done before the end of this year. If we don't get it done this calendar year, it will be in an election year, which adds complications to it.
And I guess the clear answer to your question is nobody can assess that. Even Bobby Scott and I probably have different opinions about that, and there's not a lot of things that we have different opinions about, but you know, assessing the likelihood of success is in a Congress that we don't even control the majority on our side is you know, it's a crapshoot, I guess, is the best way. Go ahead.
Good afternoon. My name's Anitra Reed, and I'm a resident of Alexandria, Virginia. And I have a comment and a quick suggestion for Ms. Eiffel. One of the ways, as part of a grassroots effort, that we can get involved is by being a poll worker. I live in Virginia, a battleground state, and last year was the first year that I was a poll worker. And I'm going to be a poll worker in our election this year. Just finished my refresher training last night. I would encourage anyone, especially minorities, we need minority representation. The hours are long, but it's one of the most rewarding things that you can do, and you really learn about the electoral process. You learn about the little hidden things that they try to do to disenfranchise voters. It's really worthwhile. But my comment suggestion is for Ms. Eiffel, and I did not know Congressman Watt was going to mention this. I get my little stubs from the NAACP, seems like monthly, about contributing to the legal fund. And I know you all it's gonna take a while for you to, sort through the lawsuits. We have a critical election coming up next year. You mentioned Shirley Sherrod, and they closed 6 out of 7 polling places in one small town. Now, similar to what you all have with the legal fund, if you all would consider developing a general fund just to work on providing transportation for folks in those areas that the rest of us could contribute to. You may not get someone to drive the folks to those places because of apathy, but you may get a lot of support, just to donate toward that to get, the transportation, because I know of that situation exists in Florida and in other places. I would be willing to contribute towards something like that.
So thank you very much. So I just want to point out that the NAACP and the NAACP Legal Defense Fund are 2 entirely separate organizations. But I will talk with Ben Jealous about precisely what you said. I know they do a lot of work around getting people to the polls on Election Day.
Yeah, and I think that's one of the main things we can do next year is to get folks to the polls.
I agree with you. Understand the Legal Defense Fund is in the litigation side, which is why I tried to differentiate in my comments. We need to be supporting both sides.
And she can get the word to the right person.
Yeah, we'll get the word to her. Yes, sir.
First, everyone here, let's give Congressman Watts a round of applause. He's done a great job in the Congress, and now may have the opportunity to oversee Fannie Mae and Freddie Mac, those organizations. That's a great opportunity. And to you, Representative Scott, thank you so much for all you continue to do. I'm nice because I want something.
Johnny, you got to identify yourself. And
everybody up here knows who you are, but nobody back there knows who you are. So identify yourself.
I am Johnny Ford, mayor of Tuskegee, Alabama.
All right.
Home of the Tuskegee Airmen and birthplace of Mrs. Rosa Parks and Tuskegee University, the pride of the swift-growing South. But I'm here today on behalf of Mayor Walls, who's the president of the World Conference of Mayors, and Commissioner Calhoun. We just finished a meeting of the National Policy Alliance, of which the Congressional Black Caucus, as you know, when you were chair of the caucus, you participated with the National Policy Alliance. We passed a resolution unanimously, going on record, calling upon the Attorney General of the United States of America to continue and to become even more active in enforcing the Voting Rights Act as it is. The Congress is working on trying to get it restored because of what the Supreme Court has done. But in the meantime, there's enough to be enforced. Now, a lot of what you all talk about up north and all over this place is theory. But in Alabama today, we're still on the battleground in terms of our voting rights being violated in Alabama today in Macon County. The National Bar Association passed a resolution unanimously in support of the lawsuit Ford versus Strange. Ms. Eiffel, we've been in touch with the defense, your organization to ask for your support. Congressman John Lewis is going to bring a resolution before the Congressional Black Caucus, asking the Congressional Black Caucus to go on record, asking the Attorney General to intervene in Alabama, because our voting rights are being violated in Alabama, not 50 years ago, but today. We need the Attorney General. So my question is, can we count on the support of you two, Congressman, when that comes before the Congressional Black Caucus?
Well, obviously, I'm not familiar with the case, so I mean, I can't commit to anything until I know what the case is about. But taking your word for it. I mean, I think you'll find the Congressional Black Caucus has been on this issue for a long time. So let's.
That's good enough. Give him a hand.
Yes, ma'am.
Hi, my name is Maya Jumper, and I want to thank the panel, but especially Ms. Eiffel as an inspiration to really Black female women who are interested in law. So thank you. My question has to do with essentially the racialization of the issue of voting rights. And my question is, as we see assaults on things like education or immigration, it doesn't seem to have as much as a racial connotation towards it, and why there's such a colorizing of voting rights, and why we can't have a public opinion that's a nation, an assault on our nation's rights as opposed to a Black right. So.
Thank you very much, and thank you for the very nice compliment. I remind people that the effort in this country to suppress the vote has consistently been motivated by the same thing. So in many ways, what we're seeing today is not really very different than what we saw in the past. The effort to suppress the vote of African Americans in the 40s and the 50s and the 60s, and in fact all through the first half of the 20th century, was motivated by the concern about power and about maintaining power. The fear was always, who will they vote for? And today the fear is, who will they vote for? It's about maintaining power. When we were at oral argument in the Supreme Court, and Justice Scalia said that the Voting Rights Act was reauthorized because it's the perpetuation of racial entitlement. That's what he called the Voting Rights Act, which was kind of, through the looking glass, right? From our perspective, the perpetuation of racial entitlement is the very heart of voter suppression. It's the reason why, in the famous case of Kilmichael, Mississippi in 2000, after the population became majority Black, the mayor and the white mayor and the town alderman decided simply not to hold an election. And it was Section 5, it was the Department of Justice using Section 5 that could compel them to hold an election that resulted in the election of the first Black mayor and 3 Black aldermen. So it's always been about power. It's always been about trying to ensure that they hold on to power. And the concern has always been about who will these voters vote for? And so that's the question we have to ask ourselves. And I think this is the citizenship issue that, it really goes to the heart of who we are. And it shouldn't be, you're absolutely right, it shouldn't be just race. If you're a citizen of the state of Texas, you ought to be demanding of your leaders in that state to tell me why, if the right to vote is fundamental, preservative of all rights, demonstrate for me the evidence upon which you base the requirement that I must now take off from work, take off from school, get my birth certificate, do whatever I have to do to get the underlying ID to be able to vote. The onus shouldn't be on the innocent voter whose fundamental rights are being affected. You may have what's the legitimate reason? Do the studies, present the studies, show the evidence, right? Every voter in Texas, not just Black people, not just the Black students that we represent at Prairie View A&M, but every resident of that state should want to know, tell me what is the reason, what is the evidence why you burden me as the voter, where for hundreds of years we've been able to be without this ID and suddenly we need it. Why do we suddenly need it? Show me the evidence. And I think this really goes to the question that you're asking in a way, because it's not enough for African Americans and Latinos to become motivated around the voting rights issue. 61% of the people who don't have the required voter ID in North Carolina are women. So we have to begin to recognize that this assault is an assault on our democracy. It utilizes race and it seeks to suppress the vote of racial minorities as a way of holding on to power. And as Anita says, it may be a temporary fix because they look into the future and they see the demographics, so it may be that fear, but that's what it is.
I don't think I can add to that, but I want to put this perspective on your question, because, yesterday in the House, we had another in a series of discussions, debates about food stamps, funding food stamps. And leading up to that debate, in the prior debate that we had, the Congressional Black Caucus took the lead and basically delaying tactics. We stretched out the day, made it inconvenient for everybody. We ultimately lost. And then in this debate that was coming up yesterday, the ranking Democrat on the committee ceded the debate to Marcia Fudge, the chair of the Congressional Black Caucus. And it was a great thing to do, but that morning we had a meeting of the Democratic caucus, and I got up in front of the caucus and said, look, the way this issue gets projected is important. There are a lot more white people in this country on food stamps than there are black people. That's right. Food stamps is not a black-white issue. And so a lot of this has to do with who takes the leadership and how issues get framed and who takes the leadership in fighting for things. It has been our history as black people over the years, because we were denied the right to vote, to be in the leadership of this. That doesn't make it a black-white issue. It makes it, the Constitution says, we're talking about all people being equal, not black people, but who has taken the fight to make that a reality. And so a lot of these issues have become black-white issues when they are not really about black or white. They are really about power and democracy and what our country stands for. We can't wave a magic wand and erase the history and make ourselves a post-racial society. We have to keep these fights going, and if we're the only ones that are going to take them to court and fight about it, the perception will always be that it's a black-white issue, but it really ain't about black or white. This is about making our Constitution meaningful and real, and the commitments that our Constitution made for every single American. 50 years later, when we celebrated in the House, it made it sound like, we had done as much for our nation. It wasn't about only black people, it was white people that we liberated throughout this 50-year history that we've been fighting about this, right? Or not 50 years, 250 years, or however long it's been now. So just because we're out here fighting about it and we're black, doesn't mean this is a black-white issue. This is a democracy issue, and we